Hello friends, in the series on the income tax cases, today we will discuss the case of Assistant Commissioner of Income Tax versus A.T. Dev Prabhat JV and others. This case has been decided by Supreme Court and the matter has been reported in 454 ITR at page number 59. The date of the judgment is 20th March 2023. This case is regarding the prosecution proceedings launched against the assessee for late depositing of TDS to the account of the central government. This is the perfect example that how much appetite the department has for the litigation, whether it will result into the generation of revenue or not. Without going into that merit, the appeals are being filed against the orders of the lower authorities. In this case, the assessee deposited TDS beyond the period which was prescribed, and the amount of late deposit of TDS was not very much, and only in one or two cases the amount was more than 50,000 and the period of delay was also not very much. When the assessee deposited the TDS was deposited with interest. But in spite of that, the prosecution was launched against the assessee and the Special Economic Offence Court upheld the prosecution proceedings against the assessee. The assessee was taking the plea of the instruction dated 28th May 1980, having number 255/339, which says that when the amount of late deposit of TDS is not significant and when the delay of the deposit of the TDS is not significant, then if the assessee deposits the TDS with interest in the due course, then the prosecution proceeding should not normally be initiated against the assessee. But in spite of that, the Special Economic Offence Court upheld the prosecution proceedings. The assessee filed the writ petition. The assessee went to the High Court against the order of the Special Economic Offence Court, and the High Court, by considering the instruction dated 28th May 1980, quashed the order of the Special Economic Offence Court, which upheld the prosecution proceedings against the assessee. It was the point of the High Court that only in one or two cases the amount of the late deposit of the TDS is 50,000 and the delay of the deposit of the TDS is not significant. So the prosecution proceedings against the assessee are not justified, especially when the assessee has deposited the TDS with the interest amount. When the High Court quashed the order of prosecution against the assessee, and when the amounts of TDS were not more than 50,000 except in one or two cases, even then the department, without applying the mind, went to the Supreme Court by filing the special leave petition, and the Supreme Court also upheld the order of the Delhi High Court that the quashing of the prosecution proceedings and the quashing of the order of the Special Economic Offence Court in this case is justified, and the prosecution proceedings against the assessee are not good in law. Friends, in this case, we have seen that for just small offences or for small delays in the deposit of the TDS, how much botheration the assessee has to bear. Sometimes it may happen that the assessee are out of financial, and it may happen that the assessee is not comfortable with the financial position for depositing the TDS. So if some lapses are there in running the business of the assessee in the form of late deposit of TDS, so in spite of paying the late fees, the interest amount, the department doesn't stop and go for the prosecution proceedings. The law is very harsh and the department takes it very casually against the assessee without keeping in mind that whenever the prosecution proceedings are launched, the assessee has to stand in the queue with the other criminals. So this is not good for the fiscal laws of the country, and this is not good for the tax administration system also. At the end of this video, once again, I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus A.T. Dev Prabhat JV and others. And the date of the judgment is 20th March 2023. And the matter has been reported in 454 ITR at page number 59. Thank you, friends.